Swayam Prabha. Digital India. Educated India.
Namaskar, I am Dr. Sumit Goyal. I am a research officer at Central Council for Research in Ayurvedic Sciences, and presently I am posted at Officer on Special Duty Technical with Secretary Ministry of Ayush. There I look after the technical work and the policy initiatives. I am an active member of the Intergovernmental Committee which was deliberating on the International Instrument on Genetic Resources and Traditional Knowledge and Associated Knowledge and Folklore at WIPO, which was recently concluded. So, today I will be speaking on the intellectual property, traditional medicine challenges and opportunities, and it is basically about traditional knowledge, but per se I will be talking about traditional medicine here. So, in this talk we will be giving a glimpse or a quintessential of some of the international policies which are there, some of the treaties where India is ratified it as a member, some of the policies and acts which are there in India to promote and protect traditional knowledge and traditional medicine as such, and then we will talk about some of the cases of biopiracy which were there in past and the success stories and how the TKDL was formed. And I will also be talking about the WIPO treaty which was recently concluded and will be ratified soon in near future, and then a small slide on how USA is doing it, and then IP Act we will talk about, challenges in brief, and then the guidelines. I will be mentioning about what are the critics has to say on the guidelines and how the future it will be shaped and the way forward. So, let us get started. Let us begin with understanding what is traditional knowledge. See, traditional knowledge is a broad word, and if we see the WIPO, it defines it as tradition means that the knowledge is created in a manner that reflect community tradition. It is often intergenerational and created and held collectively. In Indian perspective, you can talk about Ayurveda in this regard or Siddha in Tamil region. And then what is important here is, if you see, traditional therefore does not necessarily mean old, but rather it relates to the way in which the knowledge is created, preserved and transmitted. This is very important to note that we cannot say traditional means a prior art always or it is old. It could be new, it could evolve with time, but the way it is created and transmitted within generation, it is called tradition. Likewise, if we talk about traditional medicine, it is a part of traditional knowledge and it is the sum total of the knowledge, skills and practices based on the theories, beliefs and experiences indigenous to the different cultures. Like in India or in the Southeast Asia also, Ayurveda is there which was evolving in past, say it was from Charak Samhita, later on it evolved into Ashtang Sangrah, and then also it keep on evolving with time. And the way it is kept, the fundamentals make it different to the biomedical sciences which is there in present. So, moving forward, there is an interesting abstract I would like to mention here, the speech of Honorable Chief Justice Punjab in Haryana High Court. He was mentioning, quoting it at a seminar on traditional knowledge and the IP protection. He said that the apparent non-systemic manner of creation of traditional knowledge does not diminish its cultural values or its value from the point of view of technical benefit. This is important to understand because for India, we need to promote how we can promote traditional medicine in terms of R&D through IP protections, defensive or positive. We will be discussing about these two aspects also later on in our talk. So, this is important to understand what is traditional knowledge in India. Let us also understand the common term which we use, alternative medicine in Indian perspective. If you see the WHO traditional medicine guidelines, which is native to a country, and as you have seen the definition of traditional medicine. So, what is native to country is called traditional medicine. If something comes from outside that country, it is called alternative. Hence, we should not say alternative for Ayurveda or Siddha which have evolved in India. It is traditional medicine, we should learn that. Now, moving forward, the important point is what is intellectual property, right? Like if you have a physical property, you buy a land, you own it. Likewise, if something is created through your intellect, that could be considered as intellectual property. And these are the legal rights which are provided by your state and at the international forums through different treaties, which result from intellectual activity. You create something from your intellect, like you can innovate something, you have some song created, you sung a song and it could be copyrighted, or you have created some art, or likewise in India we have different artworks, or we have medicines which are which could be considered as an innovation, like drug development could be there in the medicine aspect. So, these are the to promote such innovations, to promote the rights of the creators, to promote innovations in the industries, and by the creators such rights are created, so that you should have some exclusivity with it. You can generate commerce out of it, the expense you have made for making that innovation, you can get that value out of it. So, it is important to promote R&D, we need IPR. So, in Ayush system specifically, Ayush is a term which is given to the traditional medicine practices which are codified in India. So, the IPR, especially the patent, can play a pivotal role in catalyzing R&D activities. As I have mentioned that for proving IPR, to promote IPR in terms of innovation, particularly in the biomedical sciences or in traditional medicine, patent play a major role, and to promote industries to take up R&D, we need to have a enabling ecosystem in terms of IP rights. So, there are two type of IP patents which are provided, one is product and processes. We will be discussing about it in the later slides. Now, let us understand what World Health Assembly has to say about it. World Health Assembly used to have a meeting at the UN office Geneva, and India is also a part of it, and we also follow what are the resolutions being made in the WHA, and we usually such resolutions reflects in our policies and our upcoming policies, and we are committed toward it. So, this particular health assembly also talk about encouraging research development in traditional medicine. It is very important to note that for encouraging research and development, they also speak about in another element 3.4 that supporting policies that will promote innovation based on traditional medicine. So, we need to evolve policies which will promote. It will be a whole of system approach wherein IP offices, traditional medicine ministries need to work together along with industries, identify the gaps and promote innovations. We need to promote innovations among scholars. Students should think about out of the box ideas, ease of doing things, a dosage form could be an innovation. So, different ideas can come in, you can have those studied well and apply for patents. So, such enabling provisions has been a resolution of WHA that we should promote it. Now, moving further, we talk about IPRs, how it evolved in India and what TRIPS agreement has to say. See, there are different type of IP protection, as I have mentioned that there could be trademark as mentioned in TRIPS also, copyright or related right. If you create a song, say, so it will be under the copyright. If you have to promote it through, say, somebody has created a composed a song and somebody is singing it, so their relative rights and copyrights come into play. Likewise, there is a trademark. If a particular product a company is preparing, he can obtain a trademark which is non-descriptive but distinctive to the product of the company. So, let us talk about then a geographical indication after trademark. Geographical indication provides geo-authenticity to the product, and in India we have a sui generis legislation. Sui generis legislation means we could have a tailor-made legislation or act in particular country. In India, in terms of geographical indication, we have a sui generis system which is quite enabling. We can identify a product ourselves, the government can identify it, somebody can apply for it, and there is a very enabling ecosystem in India. You might have seen recently also, you can go to the CGPDTM website, plenty of GI tags have been provided to different products of traditional knowledge pertaining to traditional knowledge in India, like Kanjivari sari is there, Lakadong haldi we will be discussing later on. And there is another act which is pertaining to traditional knowledge. If you see the Protection of Plant Varieties and Farmers' Right Act, herein also if there is a new variety or a extinct variety, it will be protected provided the distinctiveness and other criteria if it is satisfying, and farmers can earn from it if they are the knowledge holder or they were involved in its creation. And there is interesting catch here. See, if we talk about Protection of Plant Variety in Farmers Act, it is exempted from research. If as an Ayush practitioner or as a traditional knowledge enthusiast, you wish to study whether this new variety has some benefit, additional benefit in some healthcare related aspect, you can do research, and together with the knowledge holder, you can marketed. So, this could be a way out, you can study about it. And then we have IT Technology Act in 2000, and the important one is the Patent Act, which was enacted in 1970, and then as per the TRIPS agreement also it was again amended in 99, 2002 and latest in 2005. So, moving forward, when we talk about policies and legislations, as I have mentioned earlier also, India is a signatory of plenty of international treaties and they work in tandem with what we have in India. So, let us understand in brief about what we have at international forum about traditional medicine or in traditional knowledge in particular, and how to protect it. See, majority of the international treaties talk about protecting the traditional knowledge. Here we need to understand two aspects. When we talk about traditional knowledge, in IPR aspect, there are two perspectives to it. One is to protect the knowledge holders' right. See, if some community is doing something in terms of traditional knowledge in medicine as such, if we talk about, they have some knowledge which is being passed from generation, we need to protect it. We need to have a sustainable solution, because there are cases in Ghana, there is a popular case study wherein there is a massive deforestation because of the industrial exploitation of a knowledge. So, we need to talk about sustainable solutions, we need to talk about protection of the rights of the holders, and parallelly we need to promote innovations through patents and other IP acts. So, having said that, if we talk about international treaties, there are a convention of biological diversity which talk about sustainable solution, but it is more of a descriptive time, or we can say aspirational rather than substantive, as it has clauses as far as possible or they should do it. So, it is not substantive, but the major outcome of this convention of biological diversity was there are two guidelines, one Nagoya protocol and Bonn guidelines came out of it, and Nagoya protocol in particular is very important because it helped to create legislative framework for excess benefit sharing of the benefit arising from the genetic resources, which is very important, and because of it many countries worked on excess benefit sharing models, enacted them, though in India we already had that through National Biodiversity Act, which was amended in 2020, latest in 2023 it was amended, but it was enacted in 2002. There are other policies also at international framework we should know. Those are having mention of traditional medicine and traditional knowledge, but not substantive, but we should understand that for the sake of our learning. Like there is a UN resolution on control of desertification, control against desertification, UNCCD, which talks about research in traditional medicine and ensuring knowledge holders get benefit. It is called United Nations Convention on Control of Desertification. Then we talk about WTO, World Trade Organization, and trade related intellectual property rights, which is TRIPS. TRIPS also talk about all this, as we say that TRIPS say that all legislation we enact in terms of IPR, we should have equal opportunity should be given to international partners as well as the international applicants, which is a major logjam in terms of if we promote a patent in traditional knowledge in India. But this particular TRIPS is silent on protection of TK. It just mentions about IPR in general. Now, if we see when they are talking CBD, UNCCD, these all came after 2000s, but way back WHO has recognized traditional knowledge related to health, and it's talk about TM quite early in Alma Ata Declaration in 1978. And as I have mentioned in the earlier slide also, in World Health Assembly, they have made the resolutions about protecting and promoting traditional knowledge through innovations and research. And on the other side, if you can see, we have discussed about Indian Patent Act and the Protection of Plants Variety Act, and now we may be moving further to the policies which we have in India. Recently, there was a national IPR policy in 2016, which is an important document which, see, in the past when we have different acts which I have mentioned like Trademark Act, Copyright Act, Industrial Design, or we have GI indication, IPR, all are being governed by different ministries. They are not under one umbrella. So, there are challenges in between. So, this national IPR policy, the major work it has done is to bring all under one umbrella, to have a unified force behind them, to have a unified policy driving them, and to have a clear vision to promote IP. And you have seen in recent past, since 2016, there has been a positive thrust in promoting IP in different domains, and traditional knowledge being one of it. So, if we talk about IPR policy, it says that document oral traditional knowledge promotion of IPR and TK. There were guidelines released prior to this IPR policy though on processing patent application on traditional knowledge. Now, I have mentioned here Ayush because it is under deliberations that with CGPDTM, a high empowered committee is working to create another guidelines pertaining to Ayush. It is under active discussion, but this particular guidelines on traditional knowledge also speaks about Ayush, and it is being referred by the patent office. When you apply for a patent, it gives certain guiding principles 1 to 6, which talks about what could be patented and what could not be patented. And it is very important, if as a student you should go through it and understand before applying and before planning for innovations that what can be patented, because it is quite important for us to understand it before working in certain area. But now see into the different perspective. There is a protective mechanism India has developed. It is a quite a celebrated case around the globe that India has developed a very good case model, which is called Traditional Knowledge Digital Library. It has a vast documentation of 466,000 formulations of Ayurveda, Siddha, Unani, all the codified systems of healthcare. So, it provides a defensive mechanism. See, if somebody is applying for a patent in a different country, then TKDL is a mechanism. They have collaborated with different IP offices, wherein they can provide a defensive support against erroneously granted patents. So, we will be discussing about it. And then there is an interesting system in India, community level databases. There are plenty of I think players which are working on documentation of local health traditions and folklores in India, be it Ministry of Ayush or traditional transdisciplinary university. Many botany institutes and universities are working on it. There are various NGOs, but in PBR there is a mechanism of people's biodiversity registers. It is there at the ground, and they have a database of 268,000 knowledge, know-hows, how the traditional medicine works, and because of it, and the NBA we will be discussing later on, it is just intro here, that they have been able to support 5,000 patent requests they have granted, because prior their approval is required to get a patent from IP office. So, they have 5,000 patent requests granted and 220 crore benefit sharing revenue they have generated, which we will be discussing in a dedicated slide on NBA. And there is another National Environment Policy 2006, which talks about biodiversity, traditional knowledge and natural heritage. And if I count the players which are there in protection of traditional medicine, traditional knowledge, in terms of IP and other aspect, there is Ministry of Environment, which talks about National Biodiversity Authority under BDA Act. There is DPIIT, Department of Promotion of Industrial and Internal Trade, wherein there is a subordinate office which is called CGPDTM, which is the nodal office for patents, grants of patents, trademarks and patent and this geographical indication. Then we have Ministry of Tribal Affairs, which look into the rights of the tribes and other aspects, and then Ministry of Ayush, which is the nodal agency for traditional medicine in India. So, these all are there. And if we talk about Ministry of Ayush in particular, there is an act called Drug and Cosmetic Act, which is a joint act by Ministry of Health, is the main nodal agency, and there is a dedicated chapter on traditional medicine. It also gave an enabling provision wherein there are two types of medicines which can be registered in India. One is classical medicine, which is based on classical Ayurveda text, like you might have heard about Chyawanprash for that example. And then there are patent and proprietary medicine. If you innovate something and you get a patent, then also you can register it as a medicine in India and market it, and it can also be exported. And then there is proprietary medicine, but usually this term patent and proprietary is used together because it is one category, and you might have seen certain products mentioned as patent and proprietary medicine because it is a category, but majority of those products are proprietary medicine, which are based on the classical text without major innovations, but a different combination of herbs based on the textual references. So, we need to demarcate that the patent proprietary medicines which is mentioned in the cover is not the patent granted by the IP office. Now, moving forward, let us talk about the most important act, Biological Diversity Act, which is considered as a cornerstone for the preservation and promotion of Ayurveda and other traditional medicine in India. Under this, there is a National Biodiversity Authority formed under the mandate of BDA, as I have mentioned, and it is the main body for granting approval for access of biological resources by the industry, so that there is no sustainable use of the resources and there is excess benefit sharing out of the resources being used by the industries, which is given back to that local community by the NBA. And for applying of IPR also by the national or international institutions, academias or industries, they need a prior approval for accessing the genetic resource, that is herbs or plants of India, and other things also which comes under genetic resource. So, before applying of IPR, this act says that you should have a prior approval of NBA, and NBA can impose a benefit sharing fees in terms of royalty or both, or impose a condition including the sharing of financial benefit arising of the commercial utilization of such rights. So, now if we see the Patent Act, there is an in the Patent Act rule 2003 in form 1, it says that you need a prior approval. So, these are in sync. NBA says that you need prior approval, and now if the patent rule also second this thing, that you need a prior approval from the competent authority before applying for the patent. So, this is the procedure to apply for a patent and approvals which you require in India. There is an interesting we say update in terms of Biological Diversity Amendment Act in 2023. See, here I would like to tell you about importance of traditional medicine in India. There is a uniqueness about traditional medicine in India. If you talk about global community, if you go through the papers, you will be talking about non-codified, means these are not documented. You will be saying that in majority of the place traditional medicine is mentioned as orally transmitted healthcare systems or folklores. But in terms of India, it is quite different. In India, it is very well documented. There are compendias, vast compendias in terms of Charak Samhita, Shushruta Samhita, Ashtang Samgraha and many other. For example, if you take the example of Drug and Cosmetic Act, it itself says there are 54 authoritative books which are well documented ancient classical texts of Ayurveda. So, these are since antiquity in India. We cannot say a particular community is a knowledge holder, and those compendias are being researched upon, evolved with time. There are changes in different time zone. If you see the text, classical texts like Charak Samhita being the ancient one and the Ashtang Samgraha, there are changes, there are evolutions, there are new things coming in. So, one aspect is this codified knowledge. Another, again, there are certain local health traditions still prevailing in India in the communities and tribal pockets. So, this Biological Amendment Act 2023 also take into consideration this codified Ayurveda and Ayush systems along with traditional local health traditions. So, we can say it has a balanced approach. It promotes TM while protecting the biodiversity and also recognize the uniqueness of TM in India. It helps in encouraging Ayurveda in terms of ease of doing business. It has decriminalized certain activities which is toward promotion of ease of doing business and innovations. And it also talks about simplifying patent application process, but it is subject to the rules and regulations which are being framed at present. So, we cannot discuss it further here, but we can say these are the main guiding principles which are mentioned in the act which is recently enacted. Now, let us talk about why. We have spoken about protection of traditional knowledge. There is a term called biopiracy. There are two terms actually. One is biopiracy, means if somebody is coming in India, taking their knowledge and using it without proper recognition or financial support to the knowledge holder, it is called piracy. It is a theft. And another term is bioprospecting, which is quite popular these days. Industries or somebody if coming to accessing the genetic resources, say herbs or the traditional knowledge of some particular region, particularly based on genetic resources, and they are using it, studying it for the purpose of commercial gains. It is called bioprospecting. So, bioprospecting in a way is good, but it should not be with biopiracy. We need to control biopiracy and promote bioprospecting. That is the whole issue we are discussing it here. So, if we talk about biopiracy, there are classical cases, you might have heard about it. There is a case that America has taken a patent on turmeric for wound healing practices, and you all are aware that at your home also your mother or grandmother might be applying some turmeric in your wound. It is there in India, it's in vogue, and it is documented also in Ayurveda and other classical texts. Likewise, antifungal properties of neem, which is again in vogue in India, everybody is using it. And there is another diabetes medicine based of jamun, which is also a part of Ayurvedic classical text. These all three patents were subsequently revoked because of active involvement of India, but it come with the cost and time. By that time, certain amount they might have earned also out of these patents. Like for turmeric alone, if you say India has to hire a US patent attorney or lawyer to fight the case, and they have spent 15,000 USD at that time, and the cost involved in engaging a law firm in India also. So, to work with the US law office, and then they have to provide 32 citation documents which were given through TKDL, and then after probably 2 to 3 years it was revoked. Time you can check it. So, this is a successful case. There are certain failed case also. There is a very popular medicine in modern system, that is called captopril. It is used to treat hypertension and high blood pressure, and it is very vastly used all across the globe. But do you know, no benefit has flown back to the indigenous Brazilian tribe. They used to use it in the pit viper venom as a arrowhead poison. It is there in their community, but they, in the patent also they are not recognized, no benefit flown back to them. So, this is a very severe case of biopiracy, we may say. We should recognize our tribes who were the custodian, who have maintained that knowledge since so long, since antiquity, they are transmitting it through generation. We should promote it, we should protect it rather. But likewise, there is, I have shown another case, a San people of Kalahari desert. This is a successful model. On the contrary, here the benefit sharing agreement with South African Council of Scientific and Industrial Research, which is working with pharmaceutical companies to develop dietary supplement based on Hoodia, a succulent plant well known to the sand for the appetite suppressant qualities. It is a positive case. Proper MOU was made between the San people and this industry, and there is a proper access benefit sharing model in place. So, this is a positive model. Now I have mentioned about a successful case in Indian perspective like turmeric, neem, jamun, but way back then when the TKDL is not came into being, there is some lost cases also in terms of India. This is Sarpagandha. It is a very popular known herb in Ayurveda. Ayurveda physicians are using it since long, and it is very popular for hypertension and also for in psychiatry. So, it's if you say vernacular name is Rauwolfia serpentina. It came into use in biomedical psychiatry after Nathan Klein tested it on patients in Rockland State Psychiatric Hospital in New York, and then one company from Novartis, which is called Novartis, a Swiss based company. It took the patent. The patent was based on just an extract, an alkaloid which is taken out from the Sarpagandha, reserpine, which is no innovation as such. It is just an isolation of the ingredient, and they made multi-million, hundreds of $1,000,000 out of it. They had patents also, but no fund or no say benefit came to India. So, this is a lost case. Later on, now the patent has also expired and now it is open to the public, but this is a lost case. Because of such cases we require TKDL. There might be many more cases here. So, I am just citing one here. So, as I have mentioned, there could be challenges like if somebody from America apply a patent there in their country, how we will know? We will know after it is being commercialized, and then there is a lot of cost involved to get it back, like I have mentioned about turmeric. So, there has been always an argument from various countries. If you see in the slide, there are two countries are divided into two groups majorly by WIPO even. One group which is rich in genetic resources like in India, there are African countries also here, or Asia Pacific group, and GRULAC means group of countries of Latin America and Caribbean, and there is other countries which are industrialized like EU, Japan, USA and Canada. So, there was a discussion among both that there should be some mechanism, a legal binding instrument which should wherein if somebody is applying with a patent with a fraudulent intent or genetic resources he has taken as a biopiracy from other country, he should disclose the origin of that knowledge, so that proper access benefit sharing mechanism could be made in place, because you know that patent are country specific also, and there are different legislations to guide them. So, this discussion started, see it started in early 2000s and it was going on since 2 decades. Since that time there were deliberations on off different aspect, but one aspect where India stood strongly was there should be a disclosure agreement, there should be a disclosure of origin obligations among the members. So, if you talk about this treaty, which is an intergovernmental committee which is set up by the WIPO to deliberate on an international binding treaty on genetic resources and associated traditional knowledge. So, recently it was signed by 29 countries, and now it will be it will come into force when 15 countries, at least 15 parties will ratify it. and so it is in that process. And the major articles which are there, which is of interest of the countries which are genetically resource rich, like India, which is a biodiversity vast repository of traditional knowledge prone to misappropriation. Here we have created a global standard on disclosure of origin obligations. See, if a patent applicant has to apply for a patent, he need to disclose the origin, country of origin of the source of GR. See, I have taken this plant from this particular origin, and if there is an associated traditional knowledge, he need to disclose the indigenous people or local community as applicable. Like in India, we do not have a indigenous community, confined community, everybody is indigenous. So, in Indian perspective, it could be local community or as applicable, it might be from some text even who provided the traditional knowledge. But there is certain challenges though, because we cannot make it very hard and fast, we need to promote innovation. So, there is another article to it which says that if neither information is available, the applicant would have to make a declaration to that effect, affirming that the content of the declaration is true and correct to the best of the applicant. Still, we can, by having this international obligation of disclosure requirement, will help us a long way in preventing the biopiracy. Now, another interesting article in this particular legal instrument is about information system. See, majority some countries like in Africa, you say in India even, certain communities might be keeping traditional medicine or traditional medical knowledge or traditional knowledge as such as a secret. They are just transmitting it among their generations and not making it out. Now, if somebody has taken somehow has taken that knowledge from one particular member of the community, flown back to his country and then going for the patent, how the original country, the country of origin will protect it, how it will defend it. There are challenges, because IP office of that particular country, say if a scientist from USA is applying for a patent in USA, how that patent office will come to know that it is a prior art, it is a knowledge of some particular country. We need to have some information system for that. Like in India, we have a TKDL, it is a vast repository of traditional knowledge shared with the patent office, because patent office need to know the whether it is a prior art or not, and they need to have some instrument for that. Hence, this particular legal instrument says that contracting party may establish information system of genetic resource and traditional knowledge associated with genetic resource in consultation with the indigenous people, because certain knowledges could be sacred and certain countries say that we are afraid that whether this information system may be misused. AI is the new thing these days. So, with such ifs and buts, this is the article which is there now, and probably how it will be formed, what are the implications, what are the objectives and safeguarding, that will be discussed later on. So, it is an aspirational article, it is not mandatory you do it in this particular time frame. So, let us talk about traditional knowledge digital library, which is one of the most discussed case, a success story of India, which was deliberated at WIPO also, that how India is protecting their traditional knowledge through TKDL, and such case studies could be replicated in different countries. This is TKDL, a traditional knowledge digital library. It is a unique initiative of CSIR and Ministry of Ayush, hosted at CSIR at present with active support of Ministry of Ayush. It has a huge repository of 466,000 formulations of Ayurveda, Siddha, Swarikpa and Unani and yoga practices. It is linked with the modern terminologies also there, which is called traditional knowledge resource classification. It is a very good classification which is in tandem with the IP classification, international patent classification. It is available in English, French, German, Japanese and Spanish, and 16 patent office worldwide have access to this TKDL, and they are working with more IP office so that it can be expanded to maximum of the IP offices in future. There is also important aspect that 329 cases of positive outcomes, rejections, amendments have already, these are the huge number, 329 cases they have, these are the success stories we should be proud of probably. Now this brings us to another slide. We are discussing different aspects now, how to get the patent, another is protection. Till now we are talking about the protection, how we can protect it. CBD talks about protection, and we have discussed about TKDL. These all are considered as defensive protection. We have a knowledge, nobody can patent it. This is documented. But on the contrary, there is another aspect to it also, that is called positive protection. Granting the patent. If somebody has taken the patent, it cannot be misappropriation, cannot happen. This also need to be promoted, and we will be discussing about how and what are the possibilities in traditional medicine, what kind of IPRs we can take, and what are the challenges involved. So, what we will be discussing is about positive protection, which grants right to the creator or holders of IPRs. So, to begin with, there are different type of IPRs we have mentioned in the earlier slides. Trademark is one of it. Trademark are distinctive signs, logos, marks and so on used on goods and services. It is non-descriptive but distinctive. Like provisions of act could be used for protecting the brands of producers of traditional medicine. Many ASU pharmaceutical firms are protecting their products through this route. Like you might have heard about Dabur, Baidyanath, Himalaya, Jhandu and so on. There are different type of trademarks available for different well-known brands. So, to prevent they are producing some quality herbs or medicines, they can prevent or protect their product through these trademarks, which cannot be used by other person. But the knowledge involved could be used, because it is not protecting the knowledge, it is protecting the product of a particular company. So, it does not prohibit third party from using traditional knowledge without the trademark or under a different mark. So, it does not provide safeguard against the knowledge, but of the quality of the product can be ascertained through a trademark. And then there are talks about trade secret, though in medicine, if you are projecting traditional medicine in India, you are Ayurveda medicine as per DNC Act, or if you are registering a food product based on traditional medicine under FSSAI, you need to tell the ingredients. So, it cannot be a trade secret. But for a traditional practitioner or folk healer is practicing, we respect their knowledge. If they do not want to divulge it to the public, it is okay, they can keep it as a secret. But trade secret is quite different. Like Coca-Cola is a popular case, they have a trade secret, they do not divulge their ingredient or recipe of this their particular brand or product, but it cannot be as such good in traditional medicine perspective, because here we are talking about medicine, it need to be out in public. We need to check the safety also, because safety of public also matters. So, it cannot be trade secret as such in traditional medicine. So, moving forward, another is geographical indication. Geographical indication could be of some value in terms of India, because Ayurveda products are geo-specific of particular region. It could have a better features, or in terms of alkaloids, or it could be better efficacy could be there of a particular geo-specific herb. Like there is a herb in Nagaur, Ashwagandha, Nagauri Ashwagandha is quite popular. It is a process of getting a GI, it is application is under screening at CGPDTM, but there are certain cases like Shashtik Shali. It is quite popular in Ayurveda Panchkarma, Shashtik Shali rice is used. It is GI tagged for a specific area of Kerala. Likewise, a small cardamom which is there from Coorg, it is again from Kerala region, and Lekadong turmeric you might have heard of, it is there from Arunachal Pradesh. And likewise, turmeric could have a different varieties in features. They, in terms of their active ingredients, or different type of turmerics are classified in Ayurveda also for particular Ayurvedic care. So, based on those particularities and distinctness, CGPDTM has given GI tags to different kind of turmerics in India. Again, this will promote local say farmers and communities to get recognition and export their product or market their product in India and get commerce, some commerce out of it, but it cannot protect against the same use of TMK. Somebody else can also produce ashwagandha in different part of India and market it, we cannot stop it. But yes, he cannot claim it as a Nagauri ashwagandha. Now, this is geographical indication. To a certain extent, it do promote commerce in terms of protecting the traditional knowledge, but it cannot protect it completely. So, the important part is patent. Patent is the absolute safeguard of the traditional knowledge, but it comes with some ifs and buts, because in India we need to protect traditional knowledge also, traditional medicine also against biopiracy. So, the clause are quite restrictive and strong, so that no prior art get patent. And parallel it also is conducive in terms of if you can establish the novelty, inventive step, non-obviousness and all the industrial application, all the criteria of patent you can satisfy, you will get the patent. See, if you can see on the slide, in 2002 inter alia provided that an invention which in effect is traditional knowledge, or which is an aggregation or duplication of known properties, prior art of the traditional known component or components, it is not an invention. But again in 2005, there was an amendment in the Patent Act, and it extended product patent to pharmaceuticals and product items. Therefore, new formulations and processes in ASU, Ayurveda, Siddha, Unani, and now Swarikpa is also included into it. So, we can say ASSU could be patented if they meet the criteria of patentability, as I have mentioned earlier. So, there is no restrictions, but we need to be very good in scientific scrutiny how to apply. There are guiding principle to it, what can be patented, what cannot be patented. There are various gray areas into it. It is there, it is true, because like in Ayurveda, traditional medicine say it is good as a rasayana. Now, how you will understand rasayana if somebody is proving that particular medicine as anti-aging, for example. So, there are challenges, gray areas in between, which will be deliberated with due course of time, but of course, at present Patent Act is quite good for safeguarding the traditional knowledge of India. There is in fact a process patent in past also on some of the Ayurveda herbs or traditional knowledge. It is not Ayurveda, but a folklore, Jeevani, which is based on Arogya Pach, and it is quite a popular case study also. You might have heard about it. TBGRI Trivandrum has taken the patent, and some people used to quote it as access benefit sharing model also, but something went wrong with this model. What happened in this? Let us understand a case study. This will help us understand the various players involved in a patent, then if it is transferred to a industry, and then access benefit sharing, what could go wrong? This is a very good case study. See, Jeevani is a restorative or immunoenhancing anti-stress and anti-fatigue. Some scientists were going into the jungle documenting some plants, and they were accompanied by some Kani tribe people. So, while moving, Kani tribe people were eating some particular kind of herb, so that they do not get fatigued, because it is a long track. So, the scientists become curious about this plant. They further studied about this plant and isolated 12 active compounds and from this Arogya Pach plant, and developed a drug called Jeevani. They filed 2 patent applications that time, and later also many other patents for different indications. Process patents they got, no product patent. There are challenges that time. Then TBGRI transferred this technology to a private pharmacy in 1996 based on Kerala. Now, see what happened later on. These are the challenges. We have NBA in place, we have forest environment policies also. So, as a part of the benefit sharing, it was envisaged that Kani would collect and sell Arogya Pach leaves. So, this was the settlement they have made in the terms of access benefit sharing, though it is not a very good model. Ideally, the pharmacy is doing some commerce, then the benefit out of that commerce should come, some part of it should come to the tribe, but this is what they have made that time. But TBGRI has not taken the forest department approval. Ideally, there need to be an approval for using such forest produce. Only if minor forest produce are allowed as per laws to the tribes to be collected, and Arogya Pach was not of that. Later, some families also start cultivating the plant around their settlement, but could not sell the harvest since it was seized by the forest check post. Because of the same reason, there were no prior approvals. Later, this is also an important aspect in terms of India. The traditional knowledge is not confined to a very small group. Even if there is a tribe, it could be widespread tribe. Same happened in Kani tribe. Some group of Kani tribe people had an MOU with TBGRI, the deal with the TBGRI and with the pharmacy of access benefit sharing, but rest all Kani tribe people who are also the knowledge holder were not involved. So, the fight erupts in between the tribes, as all were not involved, and also then the pharmacy were also not getting the raw supply. So, this system ended way back that time, and later on the process patent also ended in 2008. So, you are not getting this medicine now in the market. So, this is a big challenge, a failure. So, we need to understand various stakeholders, various players here, like there could be a forest is also, there are laws which we need to understand before doing this access benefit sharing model in place, putting it in place, or assessing the raw material, because sustainability is an important thing. If you see the Ghana model also, there is case studies wherein massive deforestation was there because of the commercial utilization of some good herb. So, we need to be vigilant whether this herb is endangered, we need to cultivate it at large scale, then go for commerce, how to do it, what to do it. This is also an important aspect we should study before going into commerce, and you need to understand that also, and there are international treaties we should abide by, like CBD for example. So, there is another thing also, if we say it is a very good case study, there is one thing which was mentioned, I have quoted the paper also, that none of the patent given on Arogya Pach refers to the tribe name anywhere. So, this is bit saddening in terms of why it happened in India. So, there are arguments why it happened, because of they were not aware whether they should do it, because it was not quite popular that time, way back that time, that there should be access benefit sharing model, we should name the tribe, or all those things were not quite common that time. So, we cannot say it is because of some other intent. So, this is a good paper I have mentioned in down the slide. You can go through it and understand the various nuances involved in this case. Now, let us talk about the recent one. Since 2016, there has been a renewed thrust toward traditional medicine and promoting innovations in all spheres of science in India, TK one of them. This IPR policy in 2016 also talk about in-depth study to determine application of existing laws to protecting TK, GR and TCE. TCE is traditional cultural expressions like some dance forms. And then India, as it also recognizes India is a rich in traditional knowledge, and we should promote this knowledge and through necessary support and incentives. Now, after this guideline, let us move on the particular provisions which are there in Patent Act. See, these are there for to protect traditional medicine based innovation patents based on prior art, but the very same provisions incorporated in the act as TK protection measures create a bulk walk, which is rather difficult to overcome. There are challenges, we need to understand them, we need to sensitize. Actually, these are not restrictive, these are very particular what cannot be patented, but there is need to of sensitization of the applicants and the patent office also, then what can be patented beyond them, because it is quite unique. See, the fundamentals of traditional medicine, as I have quoted earlier also, one could be mentioned as rasayana. So, how you will interpret is that prior art if somebody is applying for the same product as anti-aging, for example, he has done a good research in that. So, what is the line which is drawn between the inventiveness and prior art? We need to work on it. We need to work on it through inclusive research studies and sensitization of both the stakeholders. So, these are various sections. See, 3E talks about a substance obtained by a mere admixture of resulting only in aggregation of the properties of the component. Like in TKDL, there are various herbs. If you are taking two herbs and just mixing them, there might be some additive effect even, but it is not obvious. It is quite obvious, sorry. It is obvious that the combination of those two particular herbs which are already known for a particular outcome will be having an additive effect and will be giving that same outcome. So, likewise in 3D, mere discovery of new form of known substance which does not result in the enhancement of known efficacy of the substance or mere discovery of any new property or new use of known substance is not considered as a patent. Likewise, section 3P is quite important in invention, which in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditional knowledge, traditionally known component cannot be patented. Like if you are taking some herb ashwagandha, so ashwagandha is known for anti-stress. If some person biochemist is good in extracting an alkaloid, he has extracted an alkaloid and say it is also good in say anti-stress, it will not be patented because it is obvious he is an expert in that knowledge, can extract an alkaloid and apply for it. There is no inventive step involved. So, likewise there are various guiding principles, there are 6 guiding principles, we will discuss on it. But before that, just for your information, sometimes an argument comes, let us promote traditional medicine patents in India, because we know that biopiracy concern are there, international applicants are also coming, but why not for particularly India we should promote. But there, as India is a signatory of TRIPS, the national treatment clause provide that under IPR law, there cannot be no discrimination between nationals and foreigners. This is very important. And TRIPS further also says that the TRIPS agreement also provide for a dispute settlement mechanism and imposition of penalty on a contrary that did not fulfill a treaty obligation. So, this is important and we should understand that how we treat the national, we have to treat similarly the international applications. So, unlike the case that with earlier IP treaties, as I have mentioned, the TRIPS agreement also provide for a dispute settlement mechanism and imposition of penalties on a country that did not fulfill its treaty obligations. So, we need to treat both equally, the national or the international applications. That is why we need to take that into our account, that we cannot have a differential treatment with Indians or the foreign nationals. That is why we need to be very vigilant and have a balanced approach, because on the one hand, as we are biodiversity rich country, genetic resource and traditional knowledge, we cannot afford biopiracy, and parallelly we need to promote patents. So, there is a very thin line in between, we need to work in a balanced approach. Now, let us take an example of USA. It is a very small slide just to give you a idea how it happens. In USA, there is no definition of novelty. Definition of novelty before American Invention Act, which was enacted in 2013, did not consider oral knowledge and use outside the US as prior art. So, anybody can go there and biopiracy is there. It is the cases are there even, but after AIA 2013, US is quite liberal in grant of patents on innovations. And if you see, there are lots of patents, US patents by Indian companies, even Indian research organizations are taking patents in US, because it's quite easy there to take the patents. It's very enabling because they have no genetic resource or traditional knowledge to protect. So, they are open to it. For example, I have mentioned about Manipal, Dabur, Muniala Ayurveda, Sami Labs, even CSIR have US patents. So, if we talk about how the examination goes in India, if we talk about examination, as I have mentioned, in India, if somebody applies for a patent in patent office, proper application you have submitted, they will check it, they will give it to a particular section which is considered appropriate. Like in traditional medicine, it could be traditional knowledge based on biotechnology or chemical or mechanical or likewise or medicine as such. So, they will give it to the particular section, then they will go to the TKDL, they will first search the prior art, whether it is a prior art or not. If it is a prior art, then there are 6 guiding principles which are mentioned in the guidelines I have mentioned earlier, which talks about what could be patented and what could not be patented. Because say there is a combination of herb you are proposing for the patent, and among those combination 1 or 2 herb is already having a prior art. Now, if your particular combination is not having any synergistic or additive effect beyond those prior art indications, then it is obvious, we cannot, there is no inventive step involved and it cannot be patented. But if there is some synergy you are providing, some outcome, some better outcome you can prove through research, then it can be considered as an inventive step. So, there are various guiding principles and there are various say illustrations provided in those guidelines, which you should go through and understand what can be patented and what cannot be patented. Now, if you see in this examination also of the prior art, the Patent Act warrants that the subject matter claimed in the patent application must be novel and inventive. And when we talk about inventive step, it is a clear definition is there in the Act. It says that inventive step means a feature of an invention that involves technical advances as compared to the existing knowledge or having economic significance or both. See, industrially it should be applicable, and that makes the invention non-obvious to a person skilled in that art. As I have mentioned earlier also, if somebody is skilled in extracting some alkaloid and saying I have done an invention based on the prior art, it is not an invention. You need to have some inventive step involved and it should be novel and non-obvious. So, in the last point I have mentioned about 6 guiding principle, you can check in the IP office, you can just search guidelines for IP in the traditional knowledge and you will get those 6 guiding principle and the complete guidelines there. So, there are challenges in and there are delays in patent. Say in India somebody has applied in 2010 and yet to get the patent, wherein in US the same applicant has applied in 2011 and got the patent in 2014. But things are improving now, there were challenges, we need to protect them, and US is quite open to the patents on traditional knowledge. That was the whole discussion all about, and the WIPO treaty came into being now. Let us see how things will go forward now onwards. So, let us talk about the guidelines. See, IPR guidelines were there, as I mentioned, on the processing of applications on traditional knowledge and biological material. So, if we talk about this guideline, there are publications in public domain also, like if you refer the Patwardhan, Professor Patwardhan, he also speak about this guideline that it is quite impossible for anyone to obtain any patent on medicinal plant, as all medicinal plants are invariably associated with traditional use. The challenge is these guidelines talk about certain illustrations which are on the negative side. So, there are discussions, if we see the next slide, there are certain critics which says that let us have some positive examples also, because in the patent office, if the patent examiners only look into the negative aspects of what cannot be patented, it will be challenging for him to accept some new thing. So, there should be some more examples on the positive sides also, and there should be some sensitization events between the traditional knowledge applicants who are doing the innovations and the patent offices. See, what they have argued is, these are quote unquote by Professor Patwardhan's publications and from the Professor T.C. James publications on traditional knowledge and IPR. I will be mentioning the book also in the last slide. They say that each herb is a polyherbal formulation. They could have a synergistic effect. We need to understand, see, there are challenges, as I have mentioned, there are gray areas. In traditional medicine, if something is mentioned in prior art in their own terminology, how you will understand if somebody is, say, for example, if something is mentioned good for skin and some applicant come, it is a very good anti-acne. So, whether it is a prior art or not, it is a gray area. Ideally, it should be inventive, because saying something good for skin does not say it is good for acne. There need to be a very good scientific scrutiny. Some funds is involved, some thought process is involved, innovations are involved. So, to establish particular combination good for acne. So, likewise, there could be certain examples in gray area which need to be deliberated and studied. So, the same the critics is also want to say that there could be synergistic effect, bioenhancer property could be there. See, if your particular combination may not be mere admixture, it could be bioenhancer. A particular herb, if you are adding to a prior art herb and it is enhancing its activity, this is also an innovation, or it is reducing some of the adverse effect which is associated with that particular herb. Or it could be the capacity to activate a prodrug, an active molecule under that particular herb could be activated, which is giving an additional outcome or some technical benefit other than the prior art. Or it could facilitate excretion even, that is also important. It will reduce the load on the body and probably of its metabolites. It could also be a better outcome. So, we need to understand different perspectives, because the traditional knowledge prior art is in the raw form. The terminology used are quite different. We cannot just correlate it with the biomedical terminologies as such, and there are a level of expertise, research involved while coming out or driving some uniqueness out of it, like anti-acne I have mentioned here. So, this is about guidelines. Just to end, I would like to mention about one important aspect which I have mentioned in the earlier slide also, and we should understand. When we read international documents or international policies, indigenous communities, indigenous people is quite a common word. Sometimes we also get confused what is indigenous in India. Sometimes we correlate it with some tribal pockets, but it is not so. See, the indigenous people, as per the publication also by Professor James, as the source of TK, it is mentioned in many places. The term that was developed in the context of colonization of America and Australia to distinguish the colonial settlers from the local people. But in terms of India or China, for that example, it is different. All are native, all are indigenous. So, we need to be cautious while using these words. That is why India has also mentioned during the WIPO deliberations, if you have seen in my earlier slide, when we are talking about source of origin of the traditional knowledge associated with genetic resources, there it is mentioned indigenous knowledge, local people, or as applicable. Local communities has been added by the inputs from Indian delegations also and other similar countries, wherein indigenous people is not a demarcated community, separate community. So, we need to understand this. For the way forward, let us see that in the traditional medicine or in the medical ecosystem, now the world is talking about planetary health or one health, wherein we know we all are interconnected. One thing which is happening in one part of the world could affect us also. Like we have learned during COVID-19 also, there is an urgent need to develop medicines, new medicines. We need to be prepared for the pandemics. Pandemic preparedness committee is also working in this regard. And if we have some enabling provisions toward innovations and patents in biomedicine, traditional medicine could play a major role. There is a study, if you check on the internet, by Professor Patwardhan again, it argues that if we develop a medicine based on botanicals, the amount of cost involved and the time involved is nearly half of that being developed from a new chemical entity, because for a new chemical entity the time involved is usually more than 10 years and the expenses is also on a higher side. But if we know something is there in vogue, like some medicine is there in traditional medicine which is helping in a way, you have some hypothesis based on it, and if you develop a medicine based on a botanical, it will take a comparatively very less time and less expenses. So, let us encourage that. Let us move toward together with traditional medicine knowledge, the vast knowledge we are having in our community in India and abroad also, promote them through innovation and research, give them appropriate benefit, access benefit, and also the patent to the industries in a way that it has an equitable sharing of benefit with the knowledge holder. Then only we may be able to achieve something good in tangible in terms of health. And for India also, we were not able to develop any drug in past recent quite a long time. India is not able to give a new drug to the world, and traditional medicine could be the answer for Indians to develop a new drug for the world. And for the traditional medicine experts here listening to this lecture, I would love to say, and for the other enthusiasts, innovators and researchers, scholars, that you should take up new courses are available free of cost also, which you should take up, understand different aspects of the policies, provisions and the intricacies and nuances involved in IPRs. You need to develop your capacity in this regard. There are courses related to patent examiners also, and as per the new IP policy 2016, DPIT has also initiatives like a national intellectual property awareness mission or cell for IPR promotion and management may be explored. You can explore those things, or there are short sensitization courses by IP, by WIPO or Ministry of Education. AICTE is also have certain initiatives regarding capacity building for the scholars. So, you should take up certain short courses, sensitize yourself, understand the things, and this is only the way forward. We cannot create a ecosystem wherein everything is patented and you do not have anything to use, as depicted in this picture. It is being taken from an internet source. I have mentioned the source also. And for the scholars for further reading, I would suggest you to go for these 3 books. Intellectual property, WIPO book is there, basic understanding you will get in the global scenario, what is there in the traditional medical knowledge. Then you should definitely go for this traditional medicine, intellectual property, right, law and policy perspective, a discussion paper by Professor T.C. James. It is available on FITM website. FITM is a forum of Indian traditional medicine. It is a policy think tank under Research and Innovation System, RIS for developing countries. RIS is a policy body under MEA, wherein there is a forum of traditional medicine which works on the policy initiatives and policy publications, policy research on traditional medicine. So, and the last one is the Indian and the Patent War. It's a very nice book, wherein if you see there is a chapter of Ayurvedic dilemmas. It is a very nice chapter. You will understand what are the dilemmas, as we have gone through this lecture also, the talk. You might be wondering whether we should promote patent in traditional medicine or we should protect it only. So, there are various views in this chapters also very beautifully captured of what a practitioners of Ayurveda thinks, what a traditional practitioner thinks, what an industrialist thinks. So, it is a very delightful read you will have. You will enjoy it. You should go through it. Thank you and happy learning.